Okay, folks, we'll get started. Very warm welcome from the employment team at Al Tamimi to this webinar on the new UAE employment law. I'm joined by my colleague, Ala. Ala, do you want to say hello?
Hi, everyone.
And Ala and I look forward to bringing you on a, shall we say, whistle-stop tour of the new law. We have 60 minutes. In our experience, this should take about 40 minutes to go through the slides, and then we have 20 minutes for Q&A. So please use the chat function at the on the toolbar and send in any questions you like, and we'll try to get as many as possible at the end. And just one other housekeeping matter, this is being recorded, so just to be aware of that, and we're happy to share the recording with any of your colleagues who cannot be with us today. So without further ado, we'll get started. The agenda for today is as follows. First of all, we're going to do a scene-setting conversation about the new law, the timing, and the context that the law finds itself in, and the sort of employment ecosystem in the UAE. Secondly, we'll look at key aspects of the law. Then we'll look at discrimination and harassment, and finally, I suppose the juiciest part, termination of employment. And just so you're aware, we're going to share the slides with you so you don't have to frantically take notes, particularly on the slide as regards the new types of leave. There's quite a lot of details there, so don't despair. You will get all the notes thereafter. So by way of setting the scene, this new labour law was announced about 10 days ago. It takes effect on the 2nd of February 2022. But we need to look at it in the context of what else is happening. The labour law itself refers to executive regulations to the law, which haven't been issued yet. We do expect them to be issued in December, and those executive regulations will provide much needed detail in relation to some of the issues raised in the labour law. The current labour law has been around, as you know, for 41 years. It doesn't have any executive regulations, and it didn't have any mechanism to stay current other than amending the law at the federal level, which for various reasons is something that's not done very often in the UAE. And so the only way to keep it up to date with events on the ground was for the Minister for Labour to issue resolutions. That was far from ideal. So what they've done with the new law is they've placed a number of placeholders essentially for the executive regulations to deal with. And in those executive regulations, we expect that the Minister will have the power to amend those executive regulations. Thereby, we're going to have a law that's going to remain current and up to date. Certainly, that's the expectation. But there are a number of areas when we go through the law, you will see today that we'll mention further details to be announced in the executive regulations. And there are one or two quite important areas that we're awaiting those type of details. The other thing to mention is what's happening on the immigration front. Obviously, in the UAE, employment and immigration are completely intertwined for the non-national employee. And the changes that we've seen over the last 18 months in particular on the immigration front have been quite dramatic as regards the availability of golden visas, 10-year visas, and various different types of visa in that category. Also, liberalization as regards remote working and freelancer visas. So we've seen a lot of changes on that front that don't necessarily tally with one or two elements of the new labour law, particularly the requirement for fixed term contracts, which we'll look at in some detail. But that is a little bit puzzling for us in that the immigration changes seem to suggest a longer term relationship for the non-national employee, including, by the way, changes to the period of time, the grace period when an employee is terminated. Currently, they remain in the UAE for 30 days until their visa expires. it was announced that that would be increased to 6 months. So that and some of these other changes don't really tally with the main aspect of the labour law that talks about fixed term contracts. The other thing I need to mention, and it only dropped last night, is the plethora of other laws that have been announced and which everyone on the call, I'm sure, has read about in this morning's newspapers. I think it's about 30 different laws or amendments to laws have been issued, announced overnight, and some of them have a bearing on the employment relationship, including the Data Protection Act, of course, the Penal Code, to the extent it touches upon, for example, the breach, the disclosure of confidential information. But also there was another law issued yesterday, and we only have it in Arabic only at this stage. We don't have an English copy of the law. It's Law 47 of 2021, English translation, the principles unifying work in the UAE. It's effective the same day as the new labour law, 2nd of February. And it's quite a short law, but it does mention two things of significance. One being that certain general principles will apply both to employees of the government who are subject to a completely different law, but certain principles will apply to them that also apply to private sector workers. And it also deals with end of service gratuity in a way which will be relevant to our conversation about that later on. Ala, anything you would like to add on this before we move on to the details of the new law?
No, Ivor, I think you've covered everything aside from the main purpose of today's webinar. As you've mentioned, we've had some changes yesterday that has been released in data protection, penal code, cyber crimes, companies law, data protection, the establishment of a data protection office or an authority that is going to be governing the data protection law. As mentioned, the penal code and other laws, including the immigration one as well, and we're looking forward to receive them. And I think we would probably have another webinar to discuss those when we have the law itself and the translation and probably the executive regulation of each as well.
Thanks, Ala. Just dealing with the applicability of the new law, like the current law, the new law applies across the nation to every free zone with the exception of ADGM and DIFC. But every other free zone and onshore, this law represents the minimum standard. So free zones have their own, a lot of free zones have their own employment regulations. They cannot be less advantageous to the employee than this new law. We also have employers who are not subject to the Ministry of Labour. These are onshore companies who are directly or indirectly majority owned by a government, either at the emirate level or the federal level. This law also applies to them in the same way as the labour law currently applies to them. The law is relatively quiet about emiratization, and that's not particularly surprising because the current law doesn't talk about emiratization in any meaningful way. Emiratization is dealt with by ministerial resolution, and the current law says that those ministerial resolutions that do not conflict with this law remain in place. And there's a specific mention in this law when it deals with discrimination to say that any program of nationalization is not discriminatory. So we can say that the emiratization targets remain as they are, and just because this law is silent on it doesn't change anything in that sense. So coming to the law itself, it recognizes a number of different types of employee, obviously full-time, part-time, temporary, flexible, and remote. Currently, part-time are not recognized in the labour law. They are, the Ministry of Labour has issued resolutions about part-time work, but it's not something that has been recognized in the law. And as such, currently a part-time worker working, say, 50% of the week could claim 100% of their annual leave, 100% of the statutory public holidays, maternity leave, all the leaves. There's nothing in the current law to say that those leaves should be provided pro rata. the new law changes that. So leave will be provided pro rata, and there'll be no risk for the employer. The exact details of such will be set out in the executive regulations. The other element that we want to see in executive regulations, and we're waiting for, is as regards end of service gratuity for somebody who's working part-time across 2 or 3 different employers, and how that's going to be dealt with in the law. So that'll be interesting. The other headings are, some of these things are already in practice. You know, we have remote working, we have virtual working visas in Dubai, for example. So these are an acknowledgement of where the market is currently, and the executive regulations will give us the details of each one of these categories and how it works in practice. The main aspect of the new law, and I'm sure everyone's heard about it already, is the fact that it doesn't provide for unlimited term contracts. So the current law has unlimited and fixed term contracts. The new law has no provision for unlimited term contracts, and only deals with, only mentions fixed term contracts, which are a maximum of 3 years, but can be less, and are renewable. So this is a dramatic change, and the single biggest talking point from the law. Currently, probably 85% of the working population in the UAE are on unlimited term contracts. The only sectors that issue limited term contracts, generally speaking, are in education, in K-12 schools, and construction project-based work, but the vast majority of employees are on unlimited term contracts. I appreciate some free zones do issue fixed term contracts, but it is the exception rather than the rule. So what the law says is that there's a 1-year grace period in order to move your employees from unlimited to limited term contracts. So that brings us to the 1st of February 2023. We have to transition them. The minister has the right to extend that period of time if he feels it's required for the public good. Those contracts they're called fixed term contracts, but they have characteristics of an unlimited term contract, just to make things confusing. They are fixed term. They will expire in 3 years. However, their termination is more like an unlimited term contract, and we'll deal with that shortly. If the contract, for example, expires on the 31st of December, and the employee turns up for work on the next working day, and his line manager gives him or her instructions and carries out work in the normal way, then that contract will be deemed to be renewed automatically for the same period of time. However, there's no requirement to give notice not to renew. So there's no requirement to notify an employee 1 or 3 months ahead of expiry and say, we're not going to renew this contract, which brings in a lot of uncertainty from the employee's perspective, because the contract could simply, so he or she could get a verbal assurance that the contract will be renewed, and it could simply expire with the passage of time and not be renewed. And the employee would not be entitled to any compensation or notice in that situation. And we'll look at the termination of the contract shortly, and we'll go into further detail. In relation to probation, not a huge amount has changed, but worth mentioning. It's still maximum 6-month period. However, until now, no notice is required to be served by the employer. Now the employer does have to provide notice, 14 days notice of the termination during probation. If the employee leaves the employer during probation and joins another company, then the employee is responsible, the new employer is responsible to reimburse the original employer in respect of the costs associated with recruiting that employee. And this is a recurring theme we hear from clients currently who have brought employees across at great expense, and then the employee leaves after a month and joins a competitor or another company, and there's no way to recover that cost. Well, under the new law, there is a way to recover the cost. And even if the employee leaves the UAE and comes back within 1 year from the date of commencement of their employment with the original employer, there is a liability on that employee in relation to repaying those costs. As regards leave, there's a lot going on here, but we'll just go into some of the key takeaways. And as I said, we're going to share these slides, so you'll have it all here. On annual leave, the big change is that we've moved to a use it or lose it system. I appreciate 99% of employers already have a use it or lose it system, but we've always advised, and it's the position of the Labour Court, that that wasn't recognised in the UAE Labour Law. The UAE Labour Law currently says that leave can be rolled over to the following year without limitation. Under the new law, it must be used within the calendar year unless the employer provides permission to roll over or to do otherwise. So that's a significant change, which probably reflects the market position. Sick leave, no change. Maternity leave has been extended from 45 days full pay to 45 days full plus 15 half, 60 calendar days. All references to days are calendar days except where it states otherwise. The maternity related sick leave was 100 consecutive calendar days. It's now 45 calendar days. And the nursing break, the 1 hour per day nursing break for new mothers, currently 18-month period that lasts for, under the new law, it's reduced to 6 months. Parental leave has already been legislated for, but the new law houses that requirement in the law itself, which is 5 working days. Compassionate leave and study leave are leaves one wouldn't normally see in the private sector. They do exist in the human resources law for the civil servants. Now they've been legislated for the private sector, and 3 to 5 working days for compassionate leave, depending on the degree of relationship with the deceased, and 10 working days for study leave per year. So coming to discrimination and harassment, again, the new law houses some provisions that are already there, namely the 2019-2020 decrees on equal pay and non-discrimination. And it also provides a blanket protection against bullying and sexual harassment. There's no right for the employee to bring a damages claim under the labour law. So unlike perhaps ADGM, DIFC, some other common law jurisdictions, where if the employee established discrimination or harassment, he or she could get essentially an exemplary damages claim against their employer. That's not provided for. Penalties can be imposed by the ministry of up to $1 million dirhams on the employer, but that's from the ministry. That's a regulatory fine rather than a damages award to the employee. So coming to termination of employment, the law specifically says that the employment can be terminated upon the expiry of a fixed term contract, upon service of notice, summary dismissal by mutual agreement, and for the first time ever in the UAE, by reasons of redundancy. So the word redundancy does not exist in the current law and has been brought into the new law. Turning to summary dismissal, firstly, we've set out here the current Article 120 grounds, and then we've either added in red the new wording for the equivalent, or strike through what's been removed from the gross misconduct summary dismissal grounds. Probation's been removed, but probation shouldn't have been in Article 120 in the first place because it was dealt with elsewhere in the law. So that's not a material change. There's a ground there whereby it says if the employee does not perform their basic duties and is now given 2 warnings as opposed to 1 warning previously, then they can be terminated for gross misconduct. In practice, that's next to impossible to rely on in the Labour Court, in our experience. The Labour Court will not countenance a poor performer being exited under a gross misconduct ground. They would expect notice to be served. And in a way, I'm surprised that heading has even remained in the new Article 44, because in practice, no one uses it successfully. The other element that's gone, and Allah is very sad to see it go, was where an employee works for another employer during their annual leave or sick leave. The glaring omission here was if the employee is working for another employer, not during his annual leave or sick leave, but during his normal working day, that was not and is not a ground for gross misconduct, strangely enough. So that's been removed, and there's been two new ones sort of covering the same area. One is the employee illegally exploiting his job for personal gains, and the other joining another employer without, quote unquote, complying with the rules and procedures established in this regard, which we take to mean a breach of a non-competition clause, which we'll deal with later. The difficulty with this one is by the time the old employer realizes that the non-competition clause has been breached, the employment relationship is over and he or she has joined the other employer, and hence there's not much you can do on this ground. One thing to say about all these grounds, with the exception of being absent for 20 non-consecutive days, etc., is that most of them require, in practice, a criminal conviction. So, i.e., the Labour Court would look at this and say, well, for example, assaulting a colleague, that's a criminal offence. So if you want to rely on this from an employment perspective, where is the criminal conviction, which would take 6 months to a year to achieve, and most employers simply wouldn't wait that long. So likewise, if we look at illegally exploiting his job for personal gains, that would also suggest a criminal conviction of some sort, given the word illegal being used there. So there are going to be, in the same way as there are problems currently with Article 120, Article 44 as the new law is going to be extremely challenging to rely on for any employer in our view. Ala, do you want to add anything to that one?
Definitely. So one of the fundamental changes that Article 120 currently allowed the employer to terminate immediately without notice or gratuity, or with denying employees notice and gratuity. This has been changed in the new labor law, where you can only deny the employee the notice pay, but gratuity remains. So even if the employee was terminated for misconduct or any of the events mentioned in Article 44, the employee still reserves his end of service gratuity. So that's a very important change in the new law.
Thank you, Ala. And that brings it into line with ADGM and DIFC in that sense. So, there is no reduction or forfeiture of gratuity in that scenario. Thank you. So redundancy has been recognized. The wording's a bit challenging. It talks about the closure of a facility. So from our perspective, when we're advising employers, I would say 95% of redundancy queries are relating to closure of a section, a unit, a business line. Almost never is it the whole facility. So on a literal reading of the current wording in the new law, it's not going to be of much use to our clients. But Allah, you're optimistic that the executive regulations might give us what we need as regards to clarification on that.
Definitely. So not only the executive regulation, but some of the wordings in the new labor law gives some flexibility for the judge. So previously, just to give you some background, as you mentioned, Ivor, redundancy, downsizing, restructuring, those were not concepts that the labor law recognized or accepted even in the court of law. There were some cases where the court would accept redundancy as a valid reason for termination and only award the gratuity and notice without an arbitrary dismissal compensation if the company has managed to establish that there has been suffering damages to the point that it would go bankrupt or would have to liquidate. And this would require a very high threshold of evidence. The court would appoint an expert to check the accounts of the company. They would need to check the audited reports of the company to see the profitability and losses, and if it was minimum losses or some losses, but not significant to the point that they're in the brackets and below zero, that would not be a valid reason for termination, and the court would still award some sort of compensation. As you guys know, it's up to 3 months compensation. The new law mentioned the concept of redundancy, but it wasn't very clear. It says if the establishment is closed permanently or the project is closed. So it's not quite clear whether the law mentions as the whole company went wound up, or it's just a specific sector or a specific department within the organization that shut down, and hence the redundancy, and hence a valid reason for termination. So this was discussed in the labor law in Article 42, where it says the establishment is closed permanently, or there is bankruptcy or insolvency of the employer, or any economic or exceptional reasons that prevents the continuation of the business. And again, it refers to the specific procedure that's going to be specified by its executive regulation. So it gives the judge some flexibility in saying, well, the law says bankruptcy or economic or exceptional reasons, and this word exceptional reason can be interpreted by different judges and different perspectives and different rulings, unless we see the executive regulation being very clear in terms of the events that can constitute an exceptional reason for termination.
Thanks, Ala. And moving to I've just checked the questions. We're getting a lot of questions on termination, not surprisingly. Hopefully the next slide or two will cover most of those. But as everyone would be familiar with, the current law has this concept of arbitrary dismissal, which is a termination that the court determines is unconnected to the employee's performance or conduct, in which case the employee can claim up to 3 months' salary by way of compensation. So the current labour law says you can terminate a contract with notice, and that's a justifiable way to exit the contract. However, if the reason isn't connected to the performance or conduct of the employee, then it could be held to be unfair. So there's notice plus potentially arbitrary dismissal compensation. The new law doesn't use the word arbitrary termination dismissal. Article 47 of the law there talks about unlawful dismissal, in the sense of if the employee files a case against the employer that is proven to be true, then that employee can obtain up to 3 months, the exact same award as arbitrary dismissal, up to 3 months compensation in addition to notice. And like the current law, the new law also says prior to this that a contract can be terminated by notice. So this might seem contradictory, but it's in the current law as well, that earlier, before we talk about compensation, dismissal compensation, it talks about legitimately terminating the contract. So both those principles, you can terminate the contract, but you can also be liable for compensation. That is not inconsistent in the sense that's how the current law is drafted. We wait for clarification on what the intention is here, but it's our view that whatever the intention is, the judges dealing with these cases, they're not being changed. I mean, the judges that are dealing with the cases on the 1st of February under the current law will be the same judges on the 2nd of February. They are used to viewing these things through a certain lens. They will, in our view, look at Article 47 and see the reference to 3 months compensation as the same as or very similar to the current Article 123 and arbitrary dismissal compensation. So this is our view. We don't have any case law, obviously. This time next year, we'll all be in a better position. But it's our view that a termination that's not connected to the employee's performance or conduct is still likely to lead to a potential liability under the new law. Let's see, do the executive regulations provide any further detail, but currently that's our position. And we're not talking about an expiry of a contract, we're talking about termination of a contract. So just to cover that, the expiry of fixed term contract would not trigger this in our view. Ala, did you want to add anything on that particular slide?
No, thanks.
Okay. And we'll answer, don't worry, we've seen all the questions, we're going to answer them. The current law has a very minimal section on constructive dismissal, and it doesn't call it constructive dismissal, and neither does the new law, but constructive dismissal is the term that we would all be used to describe this. And we've set out the grounds here. I mean, currently in practice, the only constructive dismissal claims really could be if the employer stops paying the employee their salary, or there's an assault upon the employee. These are effectively the only current grounds. So there's an expansion here. We've seen health and safety. We've been added, and we've also seen, interestingly, where work is fundamentally different from the job description. So up until now, we would have advised that changing the job description would not be a fundamental breach of the contract in the UAE. The fundamental breach being anything to do with salary, remuneration, leave, and the physical location of the work. So if you moved the job from Dubai to Abu Dhabi, that would be a fundamental change. But job description wasn't considered that in the courts, and now it's specifically mentioned here that it is a fundamental change. So that's worth noting as well. There's also a requirement in the new law that the employee's entitlements should be paid within 14 days. Under the current law, strangely enough, there's no provision in relation to that. And failure to do so can result in fines. Again, it's fines by the ministry. So it's a regulatory issue rather than a damages issue for the employee. Again, different to the common law approach whereby the employee can bring a claim essentially for exemplary damages. That's not the case here. It's a regulatory matter. And you'll see going through the slides, the ministry, their regulatory remit is going to be significantly expanded as regards discrimination, harassment, and policing these sections of the law. So it remains to be seen whether they will create specific units to deal with each one of these areas or not. The other thing worth mentioning is in relation to non-competition. The law says that a non-compete clause must be reasonable. The usual provisions as regards geographical area, course of work, and time, but it does say that the maximum period can be only 2 years. But then it says the executive regulations will specify provisions as regards the non-compete not being applicable in certain employees. So we would expect to see the executive regulations saying that a non-compete won't apply to anybody earning less than X, or anyone, you know, in a junior job title. That's what we expect, that it'll only apply to people in sensitive, commercially sensitive positions rather than all employees. On end of service gratuity, there's been no change to the calculation. It's on basic salary and it's on calendar days. There has been a change, as we said, as Ala rightly said, if the employee is terminated for gross misconduct, there is no forfeiture of the gratuity as there currently is. And likewise, the employee on a unlimited term contract with less than 5 years service, there's no longer the sliding scale of reductions. They get the 21 calendar days calculation pro rata. The biggest talking point on gratuity is the absence of a provision that currently exists in the law that says if you have a private pension scheme for your non-nationals who are entitled to gratuity, that can be in lieu of end of service gratuity. So it's quite common for European companies who have pension schemes back in home country to extend that pension scheme to their employees here on the basis that the employee signs a waiver whereby they forfeit any right to an end of service gratuity in the UAE in lieu of their usually better pension arrangements back home. That provision doesn't exist in the new law, which begs the question, what's the status of those tens of thousands of employees, I would say, on the 2nd of February 2022? Can they claim a duplicated benefit for gratuity and pension? The answer was unclear until about 3 hours ago when the new law that we mentioned at the outset as regards general principles for unified work in the UAE was released, and it's in Arabic only. We will share, and I've seen comments about will we share the law. We will share the law, and that does suggest that alternatives to end of service gratuity will be enforceable. So that's potentially going to clear up this open question, because this is a significant matter, and we're just waiting on clarity on that. But that would suggest that it'll be dealt with there, and that the current regime is going to be acceptable going forward.
So one thing I'd like to add here, Ivor, because I've seen some questions during the slides about the calendar days / business days. So strangely enough, everyone, there were two versions of the law that was released. The first one that we've all had that does suggest working days, and hence everyone thought this is going to be very difficult because that's basically a 30% increase in the employer's liability. The new version, the proper version that is going to be issued in the Gazette is 21 calendar days, so it remains the same.
Thanks a lot for clarifying. And yeah, the final slide before we get to the Q&A, what do employers need to do to prepare themselves? Well, obviously, we're all going to have to move to fixed-term contracts, and that's going to require new contracts to be issued by 1st of February 2023. The policies and handbooks will have to be updated to reflect the new statutory minimums and some of these new leave provisions that simply don't exist currently. Some employers who are going through, shall we say, transformation projects are using this as an opportunity to roll this in with their project. So not just changing an unlimited term contract to a limited, but also changing other terms and conditions of employment and bringing it all in as one seismic change for the organization if the organization is going through something like that. So it does represent an opportunity for some employers. So we'll come to the Q&A, folks. And Alaa, do you want to start?
I just have two final points before we proceed to the Q&As. The first one, I'm not sure if we've covered this. I know it was mentioned in one of the slides, but the employer has 1 year to adjust. So the law did allow the employers to make amends to their handbooks and their the employment contracts 1 year from the enforcement date. So by February 2023, all employers need to have all the new requirements included in the handbooks and their employment contracts amended. And the last thing I'd like to mention here is that this is a complete replacement of the previous labor law. So it's totally repealed. This is going to be the new labor law. And in terms of the remaining resolutions that has been issued by the ministry, unless it contradicts any law, any provision in the new labor law, it's going to be still effective. So if there is some provision or some resolution that is separate from the executive regulation or separate from the labor law, this one would still be in force. If it contradicts any of the provisions of the new labor law, then it's automatically repealed.
Thanks a lot. Okay, and I noticed we have questions both in the chat box and the Q&A box, but we'll I'm in the chat box, Alaa, currently, and I'll just get the ball rolling. Do we need to provide, in relation to housing, do we need to mention it if we're providing housing in the labour contract? The ministry template will have it included. I'm absolutely sure of that, for those employees that are subject to mandatory accommodation. So that will be covered. The next question is on termination. Hopefully we've answered that in the last few slides. In relation to remote working, it is recognized. The details will be per the executive regulations. And that's a good point. Is it within the UAE or outside the UAE? This labour law is concerned with employees who are in the UAE, and already we have a Dubai virtual working visa for those that are working for companies outside the UAE, but this one will be focused on UAE employers. Alaa, do you want to take a few there?
Yeah, I see here I have Does it recognize remote working within and outside the UAE for UAE-sponsored employees? It doesn't mention this clearly because it's referred to the executive regulation. So once this is released, as Ivor mentioned, probably in December, and definitely before the enforcement of the law, because we need to have the regulations before Feb, it would have the specific regulations for the remote working, flexible working, and any other sort of work. In terms of end of service, what is the difference between 21 and 30 working days? Yeah, I think we've covered this. It's still going to be 21 working days, 21 calendar days and 30 calendar days for the 5th year and above. Will the transition to fixed term contracts have an impact on end of service gratuity? The answer is no. As Ivor mentioned, it's limited or fixed term contracts in name, but not in nature. Whether the employee resigns in the middle, provides notice, and the employer terminates, provides notice, the gratuity remains the same. So I think I understand that the purpose of this question, because previously it was if you resign from 1 year to 3 years, you get third, from 3 to 5, you get 2/3, after 5, it's the same. Or in terms of fixed term contracts, if you resign anytime before 5 years, you forfeit your gratuity. That's not the case. The gratuity is fully paid once you complete the 1 year of service.
Thanks a lot. I'll pick up the next few.
Yeah, okay.
Is there a cost to updating the contract at MOL? I would say there will be, my cynical view. We await details on that, but I think there will be an administrative fee. And then I suppose the million-dollar question, what is the rationale behind the obligation of having limited term contracts only? I don't know. I mean, it is puzzling. And as we said at the outset, it's sort of, it's hard to tally with the direction that immigration are going with golden visas. Yeah, it is puzzling, honestly. What will happen to carryover days before February 2021? So this is a great question. You have a legacy accrual of annual leave going into February 2021. That will expire by February 2022. So those accrued annual leave days that you're carrying across will need to be used by the 1st of February 2023, or otherwise they will become time barred. We've answered, there's a few questions on annual leave. I think we've covered it, what it means by permission. It means the employer in their policy agrees that a certain amount of days can be rolled over to the following year. And we have a question, does the move to 3-year contracts impact existing unlimited term contracts? Yes, it does. They have 1 year by February 2023 to move across to limited term contracts. Will the notice period during probation apply for employees joining before the 2nd of February 2022? No, I mean, the new law doesn't take effect until the 2nd of February 2022, but this is a very good question because our clients are now starting to draft contracts and issue contracts that are compliant with the new law, not the current law, on the basis that there's only going to be a 2-month interregnum period, and it's easier to have it complying with the new law than the current law. So that would seem to make sense. There's a question in relation to equal pay and benchmarking. This is a question that would be absolutely relevant in the UK or elsewhere. There's no details on how that's going to be worked out. As this question and other questions have alluded to, extremely difficult to compare two employees and work out whether they're getting the equal pay for the equal work. It's quite a complex comparative exercise and benchmarking exercise to do. So it remains to be seen whether the ministry will do that. The fact that the employee themselves can't bring a case for damages on that basis may mean that this area won't get the type of attention that it would otherwise get if the employee could bring the claim directly. Alaa, do you want to pick up a few of those?
Yes, I saw a question here. End of service payments must be done within 14 days. Is it from the date of terminating the employment, date of resignation, last working date, or some suggest date of canceling the visa? We would suggest 14 days from the last working day, not from the cancellation of the visa. Is it possible to share with us? Yes, obviously we're going to share the slides and a copy of the law. Currency of salary, good question. I'm not sure if we covered this either, but
We
the
didn't.
new law did. Yeah, the new law did provide that the employer can agree with the employee on any currency, a subject that is mentioned in the employment contract. So the standard currency obviously is dirhams, but the employer and the employee can agree to a different currency.
I'll take the one
What?
on
Yeah.
semi-government. Yes, it does apply to semi-government companies. If the company is set up as an LLC or a PGSC, then it will be subject to the law. As the person who asked the question knows well, it's not subject to the Ministry of Labour themselves, but excuse me, they are subject to the law.
Probation is 14 days. The notice, what's the notice for terminating during probation? Under the new law, it's 14 days from the employer.
Great question on redundancy. Does it apply if the company globally can justify it, not locally? Great question. Remains to be seen. My bet would be it would have to have a local dimension to justify the redundancy ground, that looking at the overall P&L globally wouldn't be sufficient to justify it locally, would be my view. But great question.
Interesting. I've had a case once, and it was the parent company that suffered significant losses. And strangely enough, when the court did appoint the expert, or luckily the expert did find in his conclusion that the parent company did suffer losses, and hence they had to cut some of the people across the whole region, not just for one company. And the court did accept this at the end. But again, this is from the previous law. We do have the same judges, as you've mentioned, but we're yet to see how this is going to play out in court.
Thanks, Allah. We have an interesting question about, can we have a longer notice period than the statutory minimum? So in most cases, you can have benefits or provisions that are more beneficial for the employee, and most people would say a longer notice period is more beneficial for an employee. So the general principle is you can do that for anything under the labour law, but under notice we can't, unfortunately, because the law is explicit about this. And I know this is a big issue for academia, where it's normally 1 year's notice, and also for C-suite executives, where the notice period is normally more than 3 months. So the danger in you having a longer notice period in your internal contract is that if you're terminating the employee, they will rely on your longer notice period. But if they're resigning, they will rely on the labour law and get out on the lesser notice period. So you end up losing both directions. That's the risk with having a longer notice period. The maximum payout is still 3 months. Sorry, Ala,
Yeah.
go ahead.
Yeah, just exactly what you said. It's still 3 months compensation, up to 3 months, and it's going to be discretionary for the judge. Very good question here. As DIFC follows dues, while all other companies across the UAE follow similar number duty. There has been some speculation in the market that the ministry is going to adopt a similar scheme like dues, but it has not been released yet. As we've mentioned earlier today, or from the decrees that has been issued yesterday, there was one in specific that talks about the end of service gratuity, and it does suggest that there would be the companies can have their own pension scheme to adopt their employees into their own funds instead of gratuity. And we believe that it's going to be, as long as it's favorable than the end of service gratuity, it would be allowed. But we're yet to see this in the executive regulation.
Thanks a lot. And great question about UAE nationals. Will the expiry of a fixed term contract for a UAE national be allowed? That's a great question, because currently there's a decree in relation to the termination of UAE nationals called Resolution 212 of 2018. And that hasn't been repealed. So that still exists. But that law specifically says that the expiry of a fixed term contract for a UAE national is a trigger event that requires the Ministry of Labour to be involved in. It's treated as a termination, basically. So the expiry of a fixed term contract for UAE national is a termination that requires a particular procedure through that decree. So that's a great question. That hasn't changed. UAE nationals contracts expiring will still have to be considered in light of that 2018 decree.
Yes. Again, as I've mentioned before, if it's not mentioned in the executive regulation, then the 212 resolution would still be in force.
Yeah.
If someone resigns on the 5th of January with a 1 month notice after 3 years service, we would suggest that it would be on the previous labor law. It's just very difficult for. It would still be 21 days. Yes.
Yeah.
And that's an interesting one. What do you think, Ivor? Because if he resigned on the 5th of January, his last working day would be on the 5th of Feb, or let's say 2 months notice. That's going to be even more difficult because he's going to leave on the 5th of March. Would it? I think the if it goes to court, the judge would consider from the date of resignation,
Yes,
because
I agree.
it's going to be it's going to be the same principle if it's not in favor of the employee. If the employer terminates and then the last working day is Feb. After
Yeah.
the enforcement of the law.
And actually, on that, Ala, what we're advising to avoid any confusion about it is in that situation, you would pay in lieu of notice and bring the final day to the 31st of January. And that removes any debate about the new law applying. So just keep it clean and pay in lieu, which you're entitled to do without the employee's consent.
Good question.
There's a few there on annual leave. I think is 22 working days of annual leave legal? Yes, because it's 30. That's 30 calendar days, so that's absolutely fine. Is there a time bar, Ala, for claiming your dues? It's still
1
the
year.
1 year. Yeah, still
Yeah.
1 year. So 1 year from the termination date, you must bring your claim as an employee. Otherwise, you're time
Yeah.
barred.
Yeah, and just to add to this, so it's actually one year from the date of the maturity of the right itself. So if we're claiming gratuity, compensation, notice, then it's obviously from the termination date because this is when the entitlement is mature. But if we're claiming unpaid salaries, the employee has 1 year from the date of he is entitled to said salary, or bonus, or commission, or whatever it is.
Yeah. Another question, will the same difficulties remain with respect to enforcement of non-compete clauses? Yes, I'm afraid they will. It's always challenging and it remains to be challenging. A comment here, the end of service under the new law actually refers to working days. That's correct. That copy was updated then, and the next version that came out referred to calendar days. So that was an error in the original law issued. So that's been corrected. The rest, I think we're up to date. We're covering them. I'm just flicking through. Ala, anything you want to pick up there on the chat box?
No, when this decree will be gazetted, usually 15th of December. How will ESG apply to unlimited contracts? It's the same. 21 days and 30 days. If the employee resigns afterwards, it's going to be in the same sense as a limited term. So basically, if an employee is on a limited term and the new labor law is in effect and the employee has not changed to a fixed term contract and then he resigns, it's going to be he's not going to forfeit, or he's not going to forfeit third or 2/3 of his gratuity, because then it wouldn't make sense for other employees to be more beneficial. And this is a very standard principle in the labor law.
Yeah. Just confirming, somebody asked, please confirm if the notice period is between 30 and 90 days. Yes, it is, and cannot agree a longer period. Well, you can, but as we said a little while ago, you as the employer could end up losing in both directions. So it's probably not recommended that you would do that. I agree with the comment in relation to schools. Yes, it's going to be a big issue. I totally see that. Paternity for female employees, yes, it's separate to maternity. It's not combined. And then we're just going through them. They're coming through thick and fast. Ala, do you want to pick up any?
I have one. Are the companies obliged to pay out end of service when moving employees from unlimited to fixed? No, there's no obligation, because it's updating a contract, or it's not even renewing the contract. It's updating it as per the new law. We wouldn't find any sort of obligation on the employer, and I don't think the ministry would push for this, and would advise employees that they have to sign on the new fixed term contracts, so the companies are up to date with the new labor law.
Yeah.
Do you expect employees requesting to be compensated? from permanent to indefinite periods? Some might. I guess some employees might take advantage of the situation and say, well, I refuse to sign on the new fixed term contracts. Not sure how this will help them.
Can I pick up one?
Yeah.
Sorry, Ella.
Go ahead.
Sorry, I was just going to pick up, if you're finished, I was going to pick up one on.
Yeah, please go ahead.
On a question about changing from unlimited to limited in free zones. Yes, I mean, a lot of free zones already have limited term contracts. You know, Jebel Ali by default, Dubai Airport by default are limited. But what we expect to see is that the free zone authorities will take the lead on notifying the free zone companies as regards the changes and how to do it and when to do it. So for those template free zone contracts that you have, we would expect, you know, I don't think you need to follow that up from the template point of view. They will follow it up. But also obviously a good idea to update your internal contract at the same time as well. There's a query just about overtime and leave and working hours generally. One of the interesting things that could be done in the executive regulations is sector specific rules on overtime. Now, this is pure speculation on my part, but currently the working time, overtime, working hours, it's a straitjacket that fits office-based employees and the majority of other employees. Does it fit oil and gas? Absolutely not. You know, they work 30 days on, 30 days off. Does it fit healthcare? Absolutely not. So there are a number of sectors that would benefit from their own sector-specific regulations, and this is common in Europe, for example. And one hopes that the executive regulations would actually match what's happening in practice, because it's been in the practice for 41 years in oil and gas. No one works 9 till 5 and gets 2 hours break. It just doesn't happen on a operating oil platform. So that's just one example. And currently, for example, healthcare providers who are under the Ministry of Labour need to get approvals from the ministry to work for 24/7, 365 shifts for consecutive Friday working, etc., etc. In fairness to the ministry, they're very good at giving those exceptions for certainly for the health sector. But one can imagine the energy sector, as I said, oil and gas, and these other sectors could benefit from sector-specific regulations. And let's keep our fingers crossed and hope that there is something there.
When do you expect more clarity of the end of service versus alternate pension plan? I'd say with the executive regulations being issued, so probably December or January.
And we're into the last minute, I'm afraid. I'm sorry we didn't reach all the questions. I will, Ala and I will be happy to address any further queries you may have directly to you. After this, we'll share the presentation and our contact details. Please do reach out to us if you have any further queries. I'm conscious it was a bit of a whistle-stop tour. We hope it was beneficial, and we're ready to support you if you need anything else. And thank you for your time today. It's been great to share this hour with you. Thank you.
Thank you everyone for joining us.